So this workshop is going to cover Ladybird deeds. We're going to talk about several topics. What's the benefit of the Ladybird deed? Because there's pros and cons to that. We'll talk about each of the Ladybird deed, when to use it, when not to use it. What limitations are there for a Ladybird deed? We'll cover that as well, because it may be appropriate in some circumstances, but due to its limitations, it may not be appropriate all the time. Should a Ladybird deed be part of your estate plan? Well, the answer really depends, and we'll talk about the details of why and why not. Does a Ladybird deed protect your home? We'll cover that as well. So that really kind of encompasses the question, if you need skilled care and the state paid for your care, does it protect my home from the state getting recovery? And we'll talk about that in some detail, how that can happen. And are there better alternatives to a Ladybird deed? Well, it kind of depends on the situation, but most of the time there are. And if you do use a Ladybird deed, there are certain things you want to take in consideration. We'll talk about those in some details in a minute as well. So first of all, what is a Ladybird deed? And I'm going to abbreviate Ladybird deed as LBD throughout this PowerPoint. And what's the purpose? The primary purpose of the Ladybird deed is to let the grantor, the person that owns the home, to keep full control over the property. And when they pass away, they're going to give the property to a trust or to an individual. And the intent really is to avoid probate court, which can be a good benefit from a Ladybird deed when it's used properly. And the grantor is a person that actually grants the right. So when they sign a deed, they're the grantor of giving that Ladybird deed, giving those rights to the kids or to a trust, and that passes upon that person's passing away. So generally, the grantor would grant the property to themselves first, and then at the time that grantor passes away, that real estate automatically transfers to the person or to the trust that's named in that Ladybird deed. The exceptions would be the grantor could take other actions before they pass away. So the Ladybird deed really gives the grantor full control over that property. So they can sell a property, they can give it away, they can mortgage it, they can do whatever they want to that property. But if nothing else happens before they pass away, and that Ladybird deed still in effect, that's when that property gets actually transferred upon their death. So that's the benefit of Ladybird deed, is I can avoid probate court generally if it's drafted right, and I can give it to the right people I want, but I still retain full control while I'm alive. So that's some of the benefits of a Ladybird deed. As I mentioned, full control to the grantor, so they can sell a property, they can give it away to someone else. They can take a mortgage out on the property, but gives them full control. But they always have the knowledge that if nothing else is done, upon their passing away, it's going to go to the grantee under that Ladybird deed. It does not give any rights to the children. So if the parents draft a Ladybird deed and they sign that, giving it to one or more children, the children do not have any rights until a grantor dies. So the children can't go out and sell the property. They don't have a right to use the property. And their creditors, the children's creditors, can't go after the property as long as the grantor is still alive. So one of the benefits of a Ladybird deed, it avoids the creditors and divorce issues of children while the grantor is still alive. And if the grantor sees that the kids may have some issues with divorce or with creditors coming up, they can always take a different action and avoid giving that property to the children and changing that Ladybird deed. As I mentioned earlier, the grantor is free to sell the property, mortgage it, do whatever they want. And the transfer only takes place upon the death of the grantor at that point. A Ladybird deed is considered a beneficiary designation because it only takes effect upon the death of the grantor. So think of a checking account, for example. You may own it in your name, and you may name one of your kids as the beneficiary on that. Well, as a beneficiary, that only takes effect upon your death. Same thing with a Ladybird deed. You designate who the beneficiary is going to be, and it takes effect when that grantor passes away. And typically, if the Ladybird deed's been recorded, the next step is to record the death certificate. And at that point, then the grantee would then have the right to the home at that point in time. Ladybird deeds have been in use for more than 25 years. If you do some research online, you'll see sometimes people think that the Ladybird deed, the name came from President Lyndon Johnson when he gave his wife real estate through a Ladybird deed. That's kind of in dispute. Some people still believe that's where the name came from. Other people say, no, that's just a myth that's being spread through the internet. So dispute as to how the name came about. Ladybird deed is also sometimes called an enhanced life estate deed or transfer and death deed. It's because the real estate's still held by the owner, but it only transfers the estate when that person dies. So TOD, transfer and death, or enhanced life estate are sometimes used when you refer to a Ladybird deed. Some of the advantages of a Ladybird deed, you don't have to keep it in the drawer. A deed is effective when it's delivered. So when there's donor of intent and you deliver it to somebody, that's when it's effective. It's still effective even if it's not recorded. Now, the benefits of recording the deed, that Ladybird deed, is now you can't lose it. You know where it's going to happen if someone doesn't take any action until they pass away. So a lot of times people will record the Ladybird deed just so they know that it'll transfer to that grantee upon the person passing away. Still be aware, though, that sometimes the Registry of Deeds office, if they don't look closely at the deed, they'll think that the property has been transferred already. So I'd still probably, as a general rule, record the deed, but knowing that there's always a chance that they may try to say there's a new property owner when you record that. There's no due on sale or acceleration of a mortgage when you sign a Ladybird deed because there's no transfer of ownership. So if you have a mortgage out there, the mortgage still stays in place. The bank can't make a due on sale claim because there's no sale of the property. So the mortgage still continues. And if it's drafted properly, a married couple can still have their tenancy by entireties. So they have asset protection and it can go to the survivor, the two of them, for a married couple. And then it transfers upon the second of them to pass away. Another benefit of Ladybird deed is going to avoid probate court and the expense associated with the probate court. And one of the benefits of using it that way is if the state paid for your care in a nursing home, and there's a concept called estate recovery. And if your house went through probate court, the state can get recovery for the cost of the care that they paid for you in the nursing home. Also, there's more expense and delays later on by going through probate court, even if you didn't need care in a nursing home. Liability insurance on your home does not have to be changed because the ownership has not changed until the person's passed away. So once that grantor passes away, you want to make sure that there's liability insurance. And sometimes it may be a good idea to talk to your insurance agent and not only have insurance on the house as you as the owner of the home, but also get additional named insured, the beneficiaries that are the Ladybird deed. So upon your passing away, when transfer takes effect immediately at that point in time, if there's a fire in the house the next day or someone slips and falls and there's going to be a claim against the property, you want to make sure there's liability insurance immediately. So there's something to consider if you do draft a Ladybird deed, is to talk to your insurance carrier and maybe have your beneficiaries on that Ladybird deed also named as additional named insured under your liability policy. Taxes, there's no uncapping of property taxes and there's no rescission of the PRE, the principal resident exemption. The reason is that the property has not been transferred, so it's still in your name. Therefore, there's no chance to uncap the property taxes by leaving it in your name, and you still get the PRE when you draft a Ladybird deed. Also, there's no gift tax owed under the IRS because there's no transfer at that point. A Ladybird deed, again, is only effective when you die, so there's no gift tax even to calculate. As a general rule, for most people, they don't face the gift tax liability. Gift tax for the federal government, it's about $11.7 million for an estate. So if you make a gift of more than $15,000 in 1 year to one person, you're supposed to file a gift tax return saying, here's the amount that I transferred, but there's no tax owed, because there's no tax owed until you reach $11.7 million, which most people don't have that problem. On the other hand, you're supposed to file a gift tax return if you do make a gift of greater than $15,000. But with the Ladybird Deed, there's no transfer, so there's no even need to even calculate the gift tax. Also, there's no loss of stepped up basis when you transfer it through a Ladybird Deed. If you sign a deed now and quit claim to deed the property to your kids, they're not going to get a stepped up basis when you pass away. They're going to get the basis of the property when it goes to them. So if you transfer it early, they're going to have an earlier stepped up in basis. Whereas if you wait until you pass away, now when the property goes up in value over a period of time, they're going to have a higher stepped up in basis. So when they do sell the property, they're going to have less issue of a capital gain. So benefit of Ladybird Deed is avoid the stepped up in basis early and give the stepped up in basis upon your death. And there's no loss of capital gains exclusion under the IRC 121, because there's no transfer of the property. And you don't worry about any county or state transfer taxes, again, because a Ladybird Deed does not transfer the property when you sign it. It's only when you pass away that you start looking at those issues. Additional benefits of a Ladybird Deed, as I mentioned earlier, it is avoid estate recovery. So upon the person's passing away, if the property avoids probate court, it goes to either a trust or at least to someone else and not going through probate court. Under current rules, it avoids estate recovery. Now, Michigan is one of the 7 states that allow this. And I'm expecting at some point in time, the state of Michigan is going to say we need more tax dollars. So what they're eventually going to do is probably put a lien on the property if you use a Ladybird Deed. Hasn't happened yet, but at some point in time, I expect that to change. So one of the solutions to that issue would be looking at drafting a Medicaid divestment trust and starting your 5-year clock. Other benefits of the Ladybird Deed, if you send it to a trust upon your passing, it's got many benefits. One, if the person you leave it to dies, you don't want that estate, your home, to go through probate court, because it could go through probate court if you left it to your son, for example, and your son predeceases you and he didn't make any changes to your Ladybird Deed. That could be an asset going through your son's probate estate. So if you send it through a trust, the trust can specify, give it to my son. If he's alive, if he's not alive, give it to his kids or give it to someone else. And you can avoid probate court by using a properly drafted Ladybird Deed, sending it to a trust and have the trust address those contingencies. It's pretty difficult to put those contingencies into a Ladybird Deed. I've seen it attempted, but I think you're running the risk now. Who's going to make that interpretation? If you give it to Mary when she's alive and then the grantor dies, it's tough to put in there that there's a contingency that Mary predeceases, give it to her living children. And who are her living children? Well, you don't know until someone investigates that. And it's pretty tough to put that burden upon at that point, upon the Register of Deeds office. So if you draft it into a trust, now you've got a trustee that can address those contingencies, and the trustee can figure out where does it go and draft the appropriate deed, giving it to either Mary or Mary's living children. Another benefit of using Ladybird Deed to a trust versus a Ladybird Deed drafted going to one of the children or someone else is that a trust can have a separate share trust for the beneficiaries. So some people will draft a trust and have it free from trust when it goes to the beneficiaries. We don't do that. When we draft a trust, our trust gives the beneficiaries what they call a separate share trust. So upon the grantors passing away, those beneficiaries, if they're over 40 for default language, they can have a separate share trust. And now if they get sued, divorce, or creditor problems, the assets you leave to those beneficiaries are now protected assets through a separate share trust. And that's why I like to use a trust as a beneficiary of a Ladybird deed if we're going to draft it that way, not drafting it to an individual directly. So those are, again, some of the benefits of using a trust as the grantee in a Ladybird deed versus using individuals such as children in a Ladybird deed. Additional benefits of a Ladybird deed: it doesn't cause any loss of Medicaid exemption benefits. So if you have a primary residence and you were living there before you went into the nursing home, a Ladybird deed will not cause the loss of that Medicaid exemption. It's not a divestment. So the home stays in your name while you're in the nursing home. And then upon your passing away, under current law, the Ladybird deed will specify where it goes, and can go to a trust or it can go to individuals. So a benefit of the Ladybird deed is that sometimes when you're applying for Medicaid, if you don't have a protection trust in place for at least 5 years, you may be at that point left with the limitation of using a Ladybird deed because you can't divest the house, you can't give it away as a general rule, with some exceptions. But if you can't give it away, you don't meet those exceptions, and you have to keep the house, then you want to use a Ladybird deed to a trust so it avoids probate court upon your passing away, and again, avoiding the estate recovery. So beneficiary issues you have to look at. Grantor keeps full control during his or her lifetime. They can sell it, give it away, mortgage the property, perform other transactions regarding the real estate, and then it goes to the grantees upon that person passing away. The grantor's capacity doesn't have any effect on the Ladybird deed. So if they were competent at the time the grantor signed that Ladybird deed and they gave the property to a trust, for example, if they become incapacitated later on, the Ladybird deed is still in effect. Also, there's no concern to the grantor or the future creditors of the beneficiaries while the grantor is alive. So if the grantor is still alive and competent, the grantor can always change beneficiaries on that Ladybird deed if they see that the creditors are going to be an issue for the beneficiaries that they first named. So they can always update that Ladybird deed and give it to someone else, or more wisely, send it through a trust with separate share trust language for those beneficiaries that have creditor problems.
And Jim, just to confirm, the grantor is the owner of the property?
Right. The grantor is the person that's granting the property. They own it, and they're the ones that give property away at their death. And then the grantee are the people that's going to receive the property. It could be a trust, or it could be the kids or some other individuals. Those are the grantees. The beneficiaries of a Ladybird deed, they can't sell a property. So the beneficiaries of the grantees, they can't sell or otherwise encumber the real estate because the grantor, the owner of the property, still remains full control over that home while they're alive. And transfer only takes place upon death. So the beneficiaries can't use that pledge of that property for a loan. Creditors of the beneficiaries can't go against that home until that person, grantor, passes away, and then it goes to the grantee. And then you look at, how did the grantee receive that property? Through a trust? Well, maybe they have asset protection from creditors at that point. Disadvantages of a Ladybird deed. Property that can be countable assets unless exempt under Medicaid rules. So if you have a second home, that's one thing. You can use a Ladybird deed, but that will not prevent that property from being a countable asset. You're going to have to do something else to get qualified for Medicaid. So the second home, the cottage, another piece of property, vacant land, whatever it happens to be, other than that primary residence, is going to be a countable asset. And just drafting the Ladybird deed will not protect that property. you're going to have to address that Medicaid issue on how to make sure you still get qualified if you do need Medicaid. So Ladybird Deed won't get you qualified just because you've used that. Another disadvantage, there's no control after death unless it's conveyed to a trust, which means you can put contingencies on in that trust. So Ladybird Deed's tough to say, give it to Sam if he's alive. If he's not alive, give it to Sam's kids, but you can do that very easily in a trust. So if you don't need Medicaid, I'd rather see the trust being the owner of that property. But if you do need Medicaid, at least use a trust as the beneficiary on that Ladybird Deed. Keep that primary home in your name if you have to, because you're trying to get qualified for Medicaid at that point, and then send it to a trust upon your passing away. Now, if you don't have Medicaid issues, then you can make the trust the owner and have all the contingencies inside that trust. I mentioned earlier too that the Registry of Deeds office, they're not always familiar with the Ladybird Deed, and they may think there's a transfer of ownership once you recorded that. So just be aware of that could be an issue. So if you start getting letters asking you about the transfer of ownership, you want to make sure that you know that there is really no transfer of ownership while the grantor is still alive. That grantor still owns the property and has still full control over the property that they own. If a named beneficiary in a Ladybird Deed dies, and then the grantor will have to sign a new Ladybird Deed or risk going through probate court. So if they name one beneficiary that's passed away, you run the risk, and there's kind of a split of opinion among attorneys. Upon the grantor's death, if the grantee died first, the grantee being the beneficiary passed away, and then the grantor died without making any changes to that Ladybird Deed, now you've got two different probate estates that could be at issue. So the person that died, let's say Sam gave it to his son, John, and John died, and then Sam died second. Well, you're going to have two different probate estates at that point in time, and there's a risk of which estate's going to be addressing that Ladybird Deed, and where does that asset go? So when someone passes away, you're going to run the risk of going through probate court with the Ladybird Deed. So again, try to use the trust as the grantee and avoid that issue. So when the grantor passes away, you know that there's someone that can receive the property that's still around, that being the trust. More disadvantages of the Ladybird Deed. It's possible that your creditors can come after the house when you die with the Ladybird Deed. We've had an issue where we were not involved initially, but the person died without a will. And at that point in time, they had a Ladybird Deed drafted by another law firm that was sent to one of the kids, and then that individual passed away. And now the creditors were going after that Ladybird Deed, because in the will, you should have some language in the will that says, I don't want to pay any assets out of my estate to pay for expenses of this my death. So it could be tax issues, could be property tax, for example. And if you don't have that language in your will, you run the risk that the creditors are going to go after your assets that are going through, even though it's going through a probate estate or going through a Ladybird Deed, you still run the risk that those creditors are going to bring that back into probate court and try to attack that Ladybird Deed. So you want to make sure that there's a will in place with the right language in the will. And also you want to make sure that the Ladybird Deed sends it to a trust, not to someone that's passed away, because you could run into the problems where the creditors of the person that passed away could try to attack that Ladybird Deed. Another disadvantage of the Ladybird Deed, if you send it to your kids directly and not through a separate shared trust, now your kids could have creditors that are going after assets that are now put in their name. So again, I don't like to name kids as beneficiaries on a Ladybird Deed, because now the kids' creditors can go after that house. So the home that you owned when you passed away, goes to the kids through a Ladybird deed. And now you run the risk that the creditors can make a claim against that house. The death could trigger a property tax change because when the owners, if the property is owned, it's non-residential and not qualified ag, it could trigger some property taxes at that point in time. And it may want it to be that that home goes to someone, that property goes to someone outright free from any liabilities. So again, you'd want to use a trust to avoid that situation. And then if there's any debt that's owed, you may want to use other estate monies to pay for that. And maybe it was your intent to give the property to one of the kids, but you want to make sure the kids take it free and clear from any property taxes. So again, send it through a trust, and you can specify in the trust that if any property taxes are owed on it, then the trust should pay for that. And then you can give the property free to those kids under that circumstance. If you name multiple people in a Ladybird deed, there's multiple problems. The more people you name, the more problems you're going to come up with. You may come up with, if you name 4 kids on there, the 4 kids may not agree. Do we sell a property? Do we keep it? If we keep it, who's going to pay for the upkeep? If they want to sell it, do they agree on how much it should be sold for? What if some people want to sell it, some don't? Again, use a trust rather than naming multiple people on a Ladybird deed to avoid some of those issues as well. We also had a situation where the homeowner had a Ladybird deed, and he also sold the home on a land contract and also had a mortgage. And in the Ladybird deed, he left it to one child. And when the grantor passed away, now the home went into the grantee's name, the son's name. And the only thing the son could do at that point would be to collect the payments from the land contract, turn around and pay off the mortgage that was owed. And then at that point, the son had to sign a warranty deed to the buyer when they paid off the land contract. So the parent didn't do any favor for the son because the son got stuck with managing it, had to collect the land contract monies, had to make the mortgage payments, and then he had to sign a warranty deed. So if something went wrong with the property, he's stuck behind the warranty. On the other hand, if they properly used a trust, now the trust would sign the warranty deed, and the son wouldn't have his personal assets exposed under the warranty deed. So again, proper use of a Ladybird deed, send it through a trust if you really have to use a Ladybird deed versus making the trust the owner, but don't make one of the kids the beneficiary, especially when there's a land contract and mortgage on the property. There may not be enough money left over, and all of a sudden the son is now going to be signing a warranty deed over to the buyer. So something that probably person didn't think about when they signed the warranty deed, when they signed the Ladybird deed. Additional considerations. If you want to ensure the beneficiaries of the Ladybird deed have no title issues, you may want to buy title insurance. So something that people don't always think about, that they think, yeah, I'll just give it to this person. But at some point, if the trust or the individual is going to sell a property, they may want to have insurance, title insurance behind it. So something to think about. I think when people draft Ladybird deeds, they don't always think about, should I have title insurance on it? The Ladybird deed does not protect the non-homestead property. We kind of talked about that earlier. So it would be accountable assets. So that's I guess, additional consideration, that your primary residence could be excluded if you own the home, but not the proceeds. So you can use a Ladybird deed under that circumstance. But again, the Ladybird deed will not protect the non-homestead property from Medicaid. It's going to be accountable assets. You need to address that issue. So don't forget about that. Just because you think you've got a Ladybird deed, that non-homestead property is going to be counted, and you've got to address that issue if you apply for Medicaid at that point. Upon the death of the grantor, the remainder beneficiary becomes immediately vested and becomes the owner. So again, think about liability insurance, that once the grantor dies, the grantor that took out insurance on the property, that may have ended unless they named additional named insureds under the policy, those remainder beneficiaries on the Ladybird deed. So if parents name a trust or name kids on a Ladybird deed, think about adding to your own insurance policy additional named insureds under the policy, whoever you named as beneficiaries on the Ladybird deed, to make sure that there's no gap in insurance. Because if a fire happens or there's a lawsuit, a week later after the grantor passes away and the property's just transferred upon death, well, the grantee probably didn't think about getting liability insurance right away. And if something happens fairly quickly, you want to make sure there's some insurance for the beneficiaries at that point. Hypothetical: mom signs a standard Ladybird deed to her son where she retains the right to sell, give away, and pledge mortgage the property when she dies, and then she gives the property to her favorite son, David, and then David dies, and after that, mom dies without changing the Ladybird deed. Well, where does the property go? To the son's estate, to the mom's estate? That's where attorneys are split on that issue, and that's why I don't like to name individuals as a beneficiary on the Ladybird deed. So you're going to have a probate estate at that point in time for sure. You could have mom's creditors and son's creditors making claims against the property, and you just increase the expense of administration after mom passed away by not properly drafting the Ladybird deed by sending it to a trust, or at least if you, for some reason, you said, I'm going to send it to my son, make sure that Ladybird deed gets updated when you name someone as a beneficiary and that person passes away. Suggested solutions to Ladybird deeds: avoid them when possible. So set up a Medicaid protection trust, put the real estate in that trust for 5 years or longer, and then you don't have to worry about using Ladybird deed if you do need skilled care. So Ladybird deeds are very commonly used when someone needs care and they're in a nursing home and the state's paying for their care and they've got to keep the house as their primary residence. And then they'll use a Ladybird deed and send it to a trust or send it to one of the kids. But if you're going to avoid that situation by creating a protection trust, a Medicaid divestment trust, and put the real estate in that trust for at least 5 years, it then becomes non-countable assets. Then you don't even worry about a Ladybird deed at that point in time. Another reason why don't do it yourself is that a layperson will miss too many issues. How do you get to the property to someone else, to someone when you pass away without using probate court? And will the will of the deceased needs proper language to avoid a creditor going after their assets? So if your will doesn't have the right language in there and you send it through a Ladybird deed, you still run the risk of the creditor is going to make a claim against that asset. So again, use an experienced attorney and make sure that the trust is drafted properly, or if you have to use a Ladybird deed, those things are taken into consideration. Do you want certainty or probability in your estate plan? A lot of people will say, I used a Ladybird deed before when my parents were alive and they signed a Ladybird deed and it worked just fine for me. It's not that Ladybird deed is going to fail all the time. You just don't know when it's going to fail. And why do you want to risk a large asset? A house could be $200,000 or more to a Ladybird deed when there's other things, much more probability by setting up the assets going through a trust and not trying to use a Ladybird deed unless you really have to. And if you're going to use a Ladybird deed, at least send it through a trust at that point. And do you want to risk your life savings or other assets on a probability? So plan for certainty, not probability. Ladybird deeds have too many limitations. And if there's a better alternative, and usually there is, look for those alternatives and only use a Ladybird deed when it's intended, because it has to be used under those circumstances. But usually there's a better option. And if you plan far enough in advance, you can avoid using Ladybird Deed altogether, especially if you set up that protection trust for at least 5 years. Should a Ladybird Deed be part of your estate plan? It might be, but generally there's better options. The protection trust I talked about, that divestment trust, create that trust, get it funded, make sure it's in place 5 years before you need care. Sometimes a Ladybird Deed is needed, and if it does need to be used, make sure it's intentional and thought through, and make sure it's used for the right reason, and there's no other better alternative. And generally, name a trust as a grantee to avoid the options, the various problems that we talked about earlier. People dying away that you've named as a grantee, those beneficiaries, or the beneficiary as creditors, send it through a trust and avoid some of those headaches too. Does a Ladybird Deed protect my home from Medicaid? Well, under current law, if the Ladybird Deed is in effect and the property does not go through probate court, then the state will not get recovery from your home when you die. So you're avoiding probate court, making sure that hopefully the trust is the beneficiary on that, the grantee. And now under current law, the state will not get recovery for the care that they paid for you. The problem is Michigan is one of the 7 states that allow the use of that revocable trust to avoid a state recovery, but the state's always looking for ways to raise taxes. And at some point in time, that revocable trust will not be the best solution. And we're encouraging clients right now to plan for certainty, not probability, because that Medicaid divestment trust is recognized in all 50 states. And Michigan's one of the few states that allow you to use that revocable trust. That's the end of the slide. So Chris, do we have some questions we want to address at this point?
Well, yes, we do, Jim.
All right.
So one of the questions is a Ladybird Deed may be amended to remove or add other parties, correct?
Correct. Yep. So Ladybird Deed can always be changed. Ladybird Deed says, while I'm alive, I got full right to make all these changes to it. I can sell it, give it away. I can draft another deed, and you can always change who's going to receive that property.
Okay. Does a Ladybird Deed work for property in Illinois?
I don't practice in Illinois. I suspect it does, but I would say you should talk to an Illinois attorney to make sure that they're recognized. They're not recognized in all states, but I don't know which ones don't recognize Ladybird Deeds.
Okay.
And the other thing is, keep in mind too, that other states have different rules for Medicaid purposes too. So current law in Michigan, you can use a Ladybird Deed to avoid a lien, and Illinois may or may not allow it for Medicaid purposes. I don't know. And even if they do allow it for transferring property on death, you still want to ask the question, okay, can I avoid a lien on the property as well?
Great. Is there a stepped up basis if grantee is a trust?
Yes. So when you pass away and the assets go to the beneficiaries, the ultimate beneficiaries through the trust, they will get a stepped up basis. So you don't have to name, in other words, you don't have to name children or individuals as grantees on a Ladybird Deed to get the stepped up in basis. By sending it through a trust on your death, they'll get the stepped up in basis that way.
Okay. If a home is owned by a trust, does it avoid estate recovery?
Current law in Michigan, the answer is yes. So either trust, a revocable trust or a protection trust, divestment trust, either trust will work in Michigan under current law. And I'm expecting at some point they're going to change the revocable trust, that won't be good enough to avoid estate recovery, but the protection trust is recognized in all 50 states, that divestment trust. But Michigan's one of the 7 states that'll recognize that revocable trust.
So what you're saying is if a house is in a trust Therefore, it does not go through probate, and estate recovery lives in probate. So therefore, a house in a trust avoids estate recovery because it does not go through probate.
Correct. Yeah.
Okay, very good. Does a property have to be Ladybird deeded for 5 years in case you need to qualify for Medicaid?
Okay. So for Medicaid, they look back 5 years and see what you did with your assets. If you gave them away to someone else more than 5 years ago, they don't care. If you did something in the last 5 years, then they're going to say that could be a divestment. Now, a Ladybird deed does not start a 5-year clock because you are still the owner. So you can sign a Ladybird deed, giving it away at your death, and you could have signed it 10 years ago. That will not start the 5-year clock by drafting a Ladybird deed because you are still the owner.
So for, I think in this question, when you are applying for Medicaid, a house is a protected asset for Medicaid purposes. And if you have a Ladybird deed on that house, then it avoids going to probate. But having a Ladybird deed on your house has no bearing on the 5-year look back for Medicaid.
Correct. Yep.
Okay.
It doesn't affect the 5-year look back with the Ladybird deed.
But if you had a house and had deeded it into a trust 5 years, then that would be protected. That would be completely off the table one way or the other for Medicaid. Like if you had a cottage, for instance.
Yep.
and
If
you
it's in
put
a
that in the trust.
yeah, if it's deeded into a Medicaid divestment trust, then that would
Right.
get it off the table after 5 years.
So you really got to know what
You've got to know.
trust it needs to go into,
Right.
what the goals that the family is trying to accomplish, and then the best way to accomplish that goal.
Correct. Yeah. Most firms don't draft a Medicaid protection trust like we do. Most firms will draft a revocable trust, and that revocable trust will not start a 5-year clock.
Right. Can I put an LLC and other assets in one trust?
Yes, we've done that before. Yep. So the LLC can be owned by the trust. Sometimes if we draft a new LLC from the beginning, sometimes we'll draft it where the trust creates it. Other times we do an assignment to the trust.
Is there financial savings by doing a Ladybird deed versus a trust?
Kind of a trick question. So yeah, it's cheap. It's cheaper up front because a Ladybird deed can be drafted for $300. So we're in that ballpark, but you're not going to draft a trust for $300. On the other hand, look at it long term. What's going to happen? Well, if I put in a protection trust for 5 years, well, I just made sure that the state doesn't put a lien on the property. So that's one. So a protection trust is going to be more expensive, but in the long run, if you need care, it's going to be cheaper. 2, even if you put it in a revocable trust and you either Ladybird deed it to the revocable trust, and the revocable trust has separate share trust language for the beneficiaries. Now the beneficiaries can't lose those assets to the nursing home, to a creditor, to an ex-spouse. So long term, it's going to be cheaper that way because now the home you left, maybe a $200,000 home, won't go to a creditor or to an ex-spouse. So it can't be lost. So is a Ladybird deed cheaper? So yeah, it's cheaper to draft a Ladybird deed, but think about the $200,000 house long term, what's going to happen?
So I think what I'm hearing you say is that there are always shortcut, maybe short-term solutions, but the planning that we do here is really looking out for the long-term health and well-being of the families that we serve. And there are ways to just do this, but it's really not accomplishing asset protection from Medicaid, And so when we sit down with families, Jim does, those are some of the questions that, we talk about. What are you trying to accomplish? What type of security that do you want? Do you want to make sure that you avoid nursing home poverty?
Yeah. What are your goals?
Right.
What are you trying to accomplish, and look at long term, give you some options. But you've got to consider that, house is a pretty substantial asset from someone's estate plan. And how do we make sure that they don't lose that house when it goes to a beneficiary?
Right. Another great question coming up, after the grantor's death, is there a capital gains tax for the grantees? The house is planned to be sold in less than 6 months after the grantor's death. Any capital gains tax due?
Generally, I'm going to say talk to your CPA, but I'm going to say no, because you get a stepped up basis when you sell it. And the stepped up basis is going to be the value at the time the person passed away. And if you're selling within 6 months, well, that sounds like it's going to be sold at the fair market value at the time the person passed away. But not a tax professional, talk to them. But short answer is you should get stepped up a basis, not have a capital gains issue.
Great. Another question. My brother deceased 2 years post COVID-19. 2 years post. Less than 12 hours from when a court ruled him incompetent. Brother deceased 2 years post-COVID. Less than 12 hours from when a court ruled him incompetent. Okay, got it. A sibling addressed a Ladybird Deed, notarized. How signature was initiated by my brother is questionable due to his medical circumstances, into her and her son. Would this be reviewed by the courts if we proceed with legal action, or is it set in stone and we should be focusing our energy on transferring to a trust that would represent all siblings?
There could be an issue if the person was questionable competency when they signed the Ladybird Deed. I think that's what the question is. And you can get a court to review that.
Okay. Do I have to notify the Registry of Deeds when the grantor dies?
It's a good idea to do that, to record the death certificate. So at that point in time, the grantee knows that they're entitled to that property.
Okay. Great. Can a Ladybird Deed split a parcel between 2 kids?
You can name 2 kids on there. I've not seen it drafted where they're going to generally both be owners, but that's the problem, is that now you've got 2 kids. Are they going to get along? Do they agree how to use a property? What if one to sell it, one doesn't? But you can name 2 individuals on there. And then again, the multiple people on there, multiple problems. Someone's going to die. Now what do you do?
Right. I think we run into that a lot, and that's part of the conversation that you have with families on what are the ultimate goals, of course, but also family harmony. And I know I've heard David say many times, if you think everyone's going to be kumbaya and, get along, when in life there are frictions between siblings at times. And after someone passes away, a parent, sometimes those frictions, maybe a little bit more intense. And so to make sure everything is spelled out as clearly and not having some of these shared responsibilities may be the best bet.
And sometimes when a parent passes away, the parents were the glue that holds the family together.
Mm-hmm.
And now kids are grieving, and some kids get along great, and other times it just brings out the worst in people too.
Is there a statute of limitations that apply with the Ladybird deed and having a court to review the protocol process of the Ladybird deed?
There would be limitations. I don't know what the time frame is to look at that, to have them. So if you know that there's an issue, raise it sooner rather than later, but I don't know off the top of my head what the time frame is to have that reviewed.
Mhm. I have a protection trust and my condo is deeded to the trust. Do I need to add additional named insured clause to my condo insurance policy and my umbrella policy?
Yeah. I'd recommend that on both policies, the underlying insurance policy and the umbrella policy, name your protection trust as additional named insured.
Does that give it more protection, Jim?
It's, well, the trust owns most of that because you retain a life estate, but you have a better chance that the insurance company is going to make a payment on the claim because the insured really is the owner of that property. So you want to make sure that the protection trust is an additional named insured besides you. So just belts and suspenders.
Yep. Yeah. If property is deeded to a revocable trust and you see needing Medicaid in the future, should you quit claim to yourself using a Ladybird deed?
Generally, when you apply for Medicaid, then you would deed it to yourself and then you would do a Ladybird deed back to the trust. So it wouldn't be a Ladybird deed to yourself, it'd be a deed to yourself from the trust and then a Ladybird deed back to the trust. But that's usually done at the time you file the Medicaid, just before you file the Medicaid application. So just because you think you may need care in the next 3 months or 6 months, I wouldn't draft it at that point. But when you get ready, if you're going to be applying, then you would want to make sure that it's taken out of the trust, generally, if it's a revocable trust.
Right. Because you wouldn't want to just leave it out there anyways, unprotected before you even need the Medicaid.
Right.
Great question. Who should a trustee be in a trust? A family member?
Trustees are generally, when the parents set up the trust themselves, they're usually the first trustees. And sometimes they'll name kids as successor trustees. If they have young kids, they want to name someone that they know is financially responsible. They're going to follow the terms of the trust. Get good legal advice if they have questions. Someone you trust to handle your finances. So I don't put someone else's name on a checking account, but if you're thinking about doing that, we'll put the trust as the owner and then name trustees that you would trust to manage those finances. They're going to honor your wishes. They're going to make sure they pay the money under the terms of the trust to the, if you're still the grantor, they're going to pay benefits for you. And they're going to follow the terms of the trust when you pass away. So trustee should be someone that you know well and know that they're financially responsible themselves, pay their own bills, and they're going to do the same thing for you as well.
Excellent. I think that's it on our questions for right now. I just put out a poll. We would absolutely love your feedback on today's presentation. And this has been recorded, as I mentioned earlier, and it will be up on our website by probably tomorrow, Friday at the latest. And so if you want to relook at it again or share it with anybody, feel free. If any of the information that you learned today kind of like sparked an interest or concern that you may have, Jim does do trust reviews, and he does initial meetings with families who haven't done their estate planning or haven't done complete estate planning. And so we would welcome meeting with you. There is no charge to meet with Jim. and get your questions answered. Sometimes it could just be a phone call, and other times it could just be meeting in person, or we could do a video call as well. Whatever works best for you. So again, thank you all for coming today. If you could answer the poll, that would be really, really helpful for us. And thank you for your time today. And thank you, Jim, for
Thanks.
sharing your expertise.
Thank you, Chris, for setting this up.
Sure.
A lot of hard work. Appreciate it.
Yep. Have a great day, everyone. And I'll wait a few more minutes as people are still answering the poll.